Since there is no judge of Ukrainian nationality on the bench, Ukraine has availed itself of the right conferred upon it by Article 31, Paragraph 2 of the statute, to choose a judge ad hoc, choosing Professor Yves Daudet. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judges ad hoc. In accordance with custom, I shall first say a few words about the career and qualifications of Professor Daudet before inviting him to make his solemn declaration. Professor Yves Daudet, who is of French nationality, is a Doctor of Law and Professor, agrégé of Public International Law and Political Science. He is currently President of the Curatorium of the Hague Academy of International Law and Emeritus Professor at the University of Paris I, Panthéon-Sorbonne, where he served as the first Vice President. Professor Daudet is an arbitrator in the Court of Conciliation and Arbitration within the Organization for Security and Cooperation in Europe. He has held a number of academic and research positions in France, Mauritius, Morocco, and Côte d'Ivoire. He was a member of the French delegation to the United Nations Conference on the International Code of Conduct on the Transfer of Technology. He has been chosen as judge ad hoc on numerous occasions and is currently sitting in the case concerning dispute over the status and use of waters of the Salala, Chile versus Bolivia, the case concerning alleged violations of sovereign rights and maritime spaces in the Caribbean Sea, Nicaragua versus Colombia, and in the two cases concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan and Azerbaijan versus Armenia. Professor Daudet is a member of the editorial board of the Annuaire Français de Droit International and is a member of the French Society of International Law and the French branch of the International Law Association. He has published numerous books and articles in different areas of international law. I shall now invite Professor Daudet to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Professor Daudet, you have the floor.
Merci, Madame la Présidente. Je déclare solennellement que je remplirai mes devoirs et exercerai mes attributions de juge en tout honneur et dévouement, en pleine et parfaite impartialité et en toute conscience.
I thank Professor Daudet. Please be seated. I take note of the solemn declaration made by Judge ad hoc Daudet and declare him duly installed as Judge ad hoc in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. I shall now recall the principal steps of procedure in the present case. On 26 February 2022, Ukraine filed in the registry of the court an application instituting proceedings against the Russian Federation concerning, I quote, a dispute relating to the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, end of quote. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, Ukraine invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Geneva Convention. In its application, Ukraine contends inter alia, and I quote, the Russian Federation has falsely claimed that acts of genocide have occurred in the Luhansk and Donetsk Oblast of Ukraine, and on that basis recognized the so-called Donetsk People's Republic and Luhansk People's Republic, and then declared and implemented a special military operation against Ukraine with the express purpose of preventing and punishing purported acts of genocide that have no basis in fact. On the basis of this false allegation, Russia is now engaged in a military invasion of Ukraine involving grave and widespread violations of the human rights of Ukrainian people. End of quote. Ukraine denies that any such genocide has occurred and states that it submitted the application, I quote, to establish that Russia has no lawful basis to take action in and against Ukraine for the purpose of preventing and punishing any purported genocide," end of quote. In its application, Ukraine also accuses the Russian Federation of carrying out the actus reus of genocide by intentionally killing and inflicting serious injury on Ukrainian nationals, accompanied by what Ukraine considers rhetoric suggestive of genocidal intent. Together with its application, Ukraine also submitted a request for the indication of provisional measures, referring to Article 41 of the statute and Articles 73, 74, and 75 of the Rules of Court. According to Ukraine, the purpose of its request is to, I quote, "prevent irreparable prejudice to the rights of Ukraine and its peoples, and avoid aggravating or extending the dispute between the parties under the Genocide Convention," end of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of Ukraine is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, "Ukraine respectfully requests that the court indicate the following provisional measures. A. The Russian Federation shall immediately suspend the military operations commenced on 24 February 2022 that have as their stated purpose and objective the prevention and punishment of a claimed genocide in the Luhansk and Donetsk Oblast of Ukraine. B. The Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction and influence, take no steps in furtherance of the military operation which have as their stated purpose and objective preventing or punishing Ukraine for committing genocide. C. The Russian Federation shall refrain from any action and shall provide assurances that no action is taken that may aggravate or extend the dispute that is the subject of this application or render this dispute more difficult to resolve. D. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court." End of quote. Thank you, Madam President.
I thank the registrar. As already mentioned, immediately after the application and the request for indication of provisional measures were filed, the registrar transmitted certified copies thereof to the government of the Russian Federation. He also notified the Secretary General of the United Nations. According to paragraph 74, Article 74, paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same provision states that the court shall proceed to a decision on the request as a matter of urgency. As previously noted, this imperative must be balanced with the need to fix the date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for indication of provisional measures, had been fixed for Monday, 7 March 2022 at 10 a.m. I would now like to welcome the delegation of Ukraine. The agent of Ukraine is present in the Great Hall of Justice. The agent is accompanied by members of Ukraine's delegation, some of whom are physically present in the Great Hall of Justice, while others are participating in the hearings remotely. For purposes of this single round of oral argument, Ukraine has available to it a 3-hour sitting. In this sitting, Ukraine may, if required, avail itself of a short extension beyond 1 p.m. today, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Ukraine, I wish to draw the attention of the applicant to Practice Direction 11, which states as follows. In the oral proceedings on request for the indication of provisional measures, parties shall limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. I now give the floor to the agent of Ukraine, Mr. Anton Kornievich. You have the floor, sir.
Madam President, distinguished members of the Court, it is a great honor to appear before you as the agent of Ukraine. It is also a solemn responsibility. We are here today in this building called the Peace Palace, but at home my country faces a war of aggression. I'm standing here in a room called the Great Hall of Justice, but at home my countrymen see only the injustice of Russia's bombs and missiles falling on our cities and neighborhoods. As I stand before the court, Ukrainians are under deadly attacks. Millions of people are in imminent danger. The United Nations top human rights officials warns that there are significant civilian casualties. Russia's assault on Ukraine has prompted over 1.5 million people to flee the country. Many more are internally displaced. More than 15,000 people, most of them women and children, have taken shelter in Kyiv's subway tunnels. Babies are born underground there in tunnels, and hospitals are being shelled. All of this is a dire reality the people of Ukraine face now. I serve as President Volodymyr Zelensky envoy to the Autonomous Republic of Crimea, but the war is preventing me from doing my job. We can no longer provide state services to our citizens who reside in occupied territory, including the administrative services, education, medical services, for instance, COVID vaccinations with internationally recognized vaccines. This is, of course, not the first time that Ukraine has experienced first-hand Russia's disrespect for international law. Now the world understands the depth of its disrespect and the hate of its cruelty. The fact that Russia's seats are empty speaks loudly. They are not here in this court of law. They are on a battlefield, waging aggressive war against my country. This is how Russia solves disputes. But Ukraine has another position and respects international law and this court of law. But even still, Russia knows that international law matters. Why else would Russia try to justify its aggression? This war, Russia says, is to stop a genocide. I quote Russia's president from the morning he ordered the invasion of Ukraine. He said, quote, "We had to stop that atrocity, that genocide," end of quote. The purpose of the war, he said, was to protect people from genocide. This is a horrible lie. Putin lies, and Ukrainians, our citizens, die. It is not Ukraine who commits genocide. It is Russia and its political leadership and military personnel who commit crimes against humanity and war crimes on the territory of Ukraine. Over the past 2 weeks, I have heard many people mention World War II. Russia sullies the memory of the Holocaust by claiming to denazify Ukraine from its democratic government. I have heard others note that Europe has not seen such aggression and conflict since World War II. It is indeed appropriate to recall World War II, but for different reasons. We should recall that in World War II, Ukrainians and Russians fought together and died together to stop evil. We should recall that on the ashes of Europe after the Second World War, the world built the modern pillars of international law. Two of these pillars stand as the most important. The world witnessed aggression, and it answered with the Charter of the United Nations. The world witnessed the Holocaust, and it answered with a convention to prevent and punish the crime of genocide. The world said never again to the twin evils of Nazism, aggression and genocide. Unfortunately, today, Russia has perverted those words. It does not treat the duty to prevent and punish genocide as a sacred obligation. It treats it as a weapon. With its false claim of genocide, Russia uses one pillar of modern international legal order to destroy the other. By falsely claiming genocide to justify its crime of aggression and acts of aggression, Russia has defiled the Genocide Convention. Madam President, distinguished members of the Court, Ukraine's case is straightforward. Russia accuses Ukraine of committing genocide. Ukraine denies that claim in the strongest possible terms, and we will prove it. Russia claims that in order to stop a non-existent genocide, it can invade a sovereign state, Ukraine. Ukraine rejects this baseless claim. My message to Russia is this: let us settle our dispute like civilized nations. Lay down your arms and put forward your evidence. Ukraine respects this court and follows its orders. Russia must as well. But if Russia will not return to international law on its own, the court has the power to act. With respect, the court has responsibility to act. Russia consented to your jurisdiction under the Genocide Convention. Now it is abusing and violating that convention in order to kill Ukrainians and destroy Ukraine. Russia must be stopped, and the court has a role to play in stopping it. That is why the people of Ukraine, the government of Ukraine, the President of Ukraine, Volodymyr Zelensky, ask you respectfully but urgently to grant our request for provisional measures. Madam President, members of the court, Ukraine's counsel here will explain why provisional measures are not only warranted, but vitally necessary. First, Professor Jean-Marc Touvenin will explain that the court has prima facie jurisdiction. Second, Mr. David Zayens will provide the factual background showing that Russia's allegations of genocide are absolutely false. Third, Ms. Marnichik will explain that the rights claimed by Ukraine in this case are at a minimum plausible, which is sufficient for provisional measures to be indicated. Fourth, Mr. Jonathan Gimblent will explain that the Ukrainian people are vulnerable in an urgent need of the court's protection. Fifth, Professor Harold Honju-Ko will explain the measures Ukraine requests and why those measures must be ordered. Finally, Ms. Oksana Zolotaryova, co-agent of Ukraine, will conclude and present Ukraine's closing statement and final submissions. On behalf of Ukraine, I thank the court for the urgency you showed in convening this hearing. I thank you, Madam President, for your urgent communication to the Russian Federation under Article 74, Paragraph 4 of the court rules. I thank the court in advance for your careful attention this morning, and I thank the court for being mindful of the extreme urgency which exists now as you deliberate. If ever there was a moment in which to exercise your power to order provisional measures, this is that moment. I now ask you to give the floor to Professor Jean-Marc Touvenin.
Thank you, Mr. Kornievich.